the record, today is Wednesday, November 16th, 2016. It's just after 9 o'clock in the morning, and this is the date and time set for a rate hearing in the matter of Community Water Company, LLC. This is docket number 16-098-01. We are streaming this hearing, so I need all of you who are going to be participating to make sure your microphones are turned on and to pull them right up close to you and not to get lazy about using them as we proceed. All right, let's get appearances on the record. The division initiated this matter, so for the division we have
Patricia E. Schmid with the Attorney General's Office representing the Division of Public Utilities. With me as the division's witnesses, we have Mr. Bill Duncan and Mr. Mark Long.
Thank you. And for Community Water Company,
Emily Lewis of the law firm of Clyde Snow and Sessions.
Stephen Clyde from Clyde Snow and Sessions.
And our witnesses today will be Stacy Wilson, and to be joining us soon is Mike Volkman of Community Water and Summit Water Distribution Company.
thank you. We also have a number of interveners in this matter. I just want to make sure who's here. Francis Amendola is here. E. Scott Savage is here. Terry Lang, thank you. William Grenny, thank you. Van J. Martin. Art Brothers is not with us, all right. And Guy Rawson. No? Okay, thank you. All right. Is there any housekeeping or procedural matters that any party wants to take care of as we get going here? Go ahead. Okay, thank you.
On that, I would just like to note that because it will be read here somewhat indeed out of order, the division will not have as much time to respond to it. So after that is read, we would request a break.
That's fine. Thank you. We do have a public witness hearing scheduled today at 12 o'clock. If we conclude this rate hearing before 12, we'll just break and then reconvene at 12. If it looks like we're going to need the time for this rate hearing right up until 12, we can talk about that as we get closer. All right. All right, so let's go ahead and begin. Ms. Schmidt?
Thank you. Mr. Long was sworn at the interim rate hearing, so I believe that he does not to be sworn again. However, Mr. Duncan was not sworn at that hearing. Could he please be sworn in?
Mr. Duncan, do you swear to tell the truth today?
Yes.
Thank you.
Before we proceed with the statement that Mr. Long is prepared to give, I have just a couple of questions for Mr. Duncan, and then I will request the admission of his testimony. Mr. Duncan, could you please state by whom you are employed and in what capacity?
Yes, I'm employed by the Division of Public Utilities. I'm the manager of the telecommunications and water section.
In that, you participated in this docket on behalf of the division.
Yes, I have.
Did you prepare or cause to be prepared the direct testimony pre-marked as DPU Exhibit Number 1.0-DR in confidential and redacted form that has been filed in this docket?
Yes.
Do you have any changes or corrections to that testimony?
No.
With that, the division moves the admission of Mr. Duncan's direct testimony pre-marked as DPU Exhibit Number 1.10-DR in both confidential and redacted forms. This was filed on June 13th, 2016.
Ms. Lewis, any objection?
No objection.
Mr. Amendola? Mr. Savage? Mr. Lang? Mr. Grenny? Mr. Martin? Thank you.
Mr. Long's direct testimony, I believe, was admitted in the interim rate hearing, but if not, I would like to move that that be admitted along with his rebuttal testimony marked as DPU Exhibit Number 1.0-R, the exhibits that accompany that, which are 1.1R through 1.3R, and it says R-DIR, but that is incorrect. It should just be 1.3R. And his surrebuttal testimony, pre-marked as DPU Exhibit Number 1.0-SR. Rebuttal testimony was filed on November 2nd, and surrebuttal testimony was filed on November 14th. The division requests that these testimonies be admitted.
Any objection from any party? Okay, thank you. Those are admitted.
Thank you. Mr. Long, do you have a statement to give today?
Yes.
Please proceed.
Okay. First, the division would like to commend the company on its cooperation and open dialogue through this long process. The division is also appreciative of the efforts put forth by the interveners and believes that the amended rates proposed by the division are a better reflection of the costs of operating the water system because of the interveners' willingness to participate. In general, all parties involved have acknowledged that a rate increase is needed for the continued operations of community water to ensure a safe and reliable water system. First, I'd like to give a little background on community water. Community water is located near Park City, Utah, and currently serves 504 customers, with an additional 2 customers paying a standby fee. The company's first tariff was issued on January 18, 1989. The last rate increase of record took place in January of 2002. The rates have remained the same now for almost 15 years. Community Water was acquired by its parent company, TCFC, around 2013. TCFC has expressed that it is not in and does not desire to be in the water business. Since acquiring the company, TCFC has explored and continues to explore avenues to transfer ownership of the company to another entity. However, the issue of transfer is not before us today. Let me emphasize again, neither the Commission or the Division has been notified of the transfer of community water, and to the best of the Division's knowledge, a transfer of community water is only speculation at this point and is not in the scope of this proceeding today. The Division is proceeding with this rate case as if community water is and will be an ongoing concern. Regardless if a transfer takes place or not, the existing rates and rate structure does not cover the fixed operational costs of the company. And it certainly does not cover needed infrastructure repairs or allow for the funding of a capital reserve fund for future infrastructure costs. To that end, the company has recently applied for 2 other rate increases, one on November 6, 2014, and another on July 21, 2015, but has subsequently withdrawn both applications. On March 15, 2016, the Division was ordered by the Utah Public Service Commission to file a rate case on behalf of Community Water. The Division filed its recommendation for a rate increase for Community Water in its direct testimony on June 14, 2016. To help fund the operational costs of the company in a more timely manner, Community Water filed an application for an interim rate increase on August 25, 2016. A hearing regarding the request for interim rates was held on September 13, 2016. The Division, the company, and several interveners participated in this hearing. On September 15, 2016, the Public Service Commission issued an order approving the interim rate increase. Community Water and several interveners subsequently filed direct testimony on or before September 21, 2016. In their direct testimony, some interveners provided information that the Division was not aware of when the Division filed its direct testimony. The Division subsequently amended its recommended rates to account for this new information in its rebuttal testimony of November 2, 2016. In addition to the Division's rebuttal testimony, 2 interveners also filed rebuttal testimony. On November 14, 2016, the Division filed its rebuttal testimony and reaffirmed the rates the Division recommended in its rebuttal testimony. The Division believes there are several outstanding issues that the Division wishes to touch on briefly. One of the main areas of concern among several interveners involves the metering and billing of the several different types of customers. For example, this water system serves individual homeowners, townhouses with shared landscape meters, and condo units with both shared indoor meters and shared landscape meters. The division's initial recommendation was interpreted by many of the customers that the rate structure was tied to the number or type of physical meters in the water system. Through testimony, the division has clarified that its recommendation is based on the number of connected customers and not on the number or type of meters. The division refers to the direct testimony of Ms. Stacy Wilson for specific examples. The division is confident that Community Water will bill appropriately if the division's recommendation is approved by the commission. Community Water has purchased all new billing software and has completed one billing cycle, which implemented the interim base charge and reflected the prior approved tier charges. This was done successfully, although with a couple of small hiccups. I know that Ms. Stacy Wilson and others have spent a considerable time and hard work in preparing the new software to handle the complex billing issues in this system, and it's amazing that the first run went as smoothly as it did. Even more encouraging, the affected customers and company worked together for a solution to fix any of the minor issues that arose. One additional comment regarding the billing. In the division's rebuttal testimony, the division made reference to the billing for the Red Pine Clubhouse to be included as part of the pool of the 200 Red Pine condo units. However, after reading Ms. Stacy Wilson's rebuttal testimony, the division wishes to clarify its position concerning the clubhouse. The division agrees with Ms. Wilson's rebuttal testimony that the clubhouse should be included with the other 200 condo units for irrigation purposes, but should be treated as a standalone connected customer subject to its own base rate charge and tiered 12,000-gallon usage rates for non-irrigation uses. Yesterday evening, the division was notified by an intervener that another clubhouse within Community Water service area associated with Hidden Creek condos does not have its own meter to monitor its inside use, and therefore its inside water use is combined with the pool of the 130 condo units. However, the division stands by its recommendation as stated above regarding the Red Pine Clubhouse. If the Hidden Creek Clubhouse had its own connection, the division would also recommend to treat it as an individual connection. Unfortunately, that is not the case here, but in the division's opinion, that does not preclude the Red Pine Clubhouse from its inside water use being monitored as a standalone unit. Perhaps this is something that, regarding the Hidden Creek Clubhouse, is an issue that the company may want to address in the future. Another issue involves the continued need of Community Water for major infrastructure repairs and replacements that are not covered in rates in this rate case. The division acknowledges that the infrastructure is suffering from past neglect and will require significant amounts to be spent on repairs and maintenance in future years. The division believes that the annual amounts of $52,000 set aside as capital reserves and the additional $18,319 set aside specifically for system repairs are conservative amounts and will not be sufficient to repair or replace much of the extensive infrastructure needs of Community Water. The division agrees with the company that at this time its estimates lack the details needed to be included in current rates. Additionally, if the company is not transferred to an unregulated entity, the company will likely need to file another rate case with supportive details to request the funds needed to improve the system. Some interveners have also expressed to the division that they believe the rate should be higher than the division's recommendation. The division has reviewed the intervener's information, and the division stands by its amended rates based on known, measurable, and verifiable information the division has before it. The next issue the division wants to address is the division's inclusion of the $6,458 for water purchased from Summit Water as part of the variable rate expense in the test year 2015. Some interveners believe that it is an occasional or isolated occurrence and should not be included as part of the rates in the test year. The division understands the concern about including this purchased water, but feels that it is important as part of full cost pricing to include this amount. Although isolated repairs may be made to the system from time to time, temporarily reducing the need for purchased water, this is an old water system that has neglected necessary repairs and replacements for many years. By including this cost in rates, the company should have some additional funds to either purchase additional water or make the related necessary repairs as needed to maintain this aging water system. In conclusion, the division recommends to the Public Service Commission that it approves the rates and rate schedule set forth on page 13 of my survey rebuttal testimony. These rates and rate schedules are also the same as set forth on page 26 of my rebuttal testimony. The division recommends that the Public Service Commission approve the revised tariff referenced as Exhibit 3 and provided as part of my direct testimony, updated as necessary to conform with the Commission's order. Note that this revised tariff includes a $10 late fee and interest at 18% on unpaid balances, as well as updated rules and regulations generally applicable to all regulated water companies. The division also recommends that the PSC order the company to file its revised tariff with the Commission within 60 days of the Commission's final order. And finally, the division recommends that the Commission order Community Water within 60 days of the Commission's final order to issue a company credit to any customer's account where the customers were overbilled using the interim rates, or to charge a fee for those customers who were underbilled using the interim rates. The division recommends that the Commission approve the amended rates as set forth in my rebuttal and surrebuttal testimony, approve the revised tariff set forth in my direct testimony, updated as necessary, and order the true-up between the interim rates and the recommended rates as specified above. The division believes that its recommendations will result in rates that are just and reasonable, and that these recommendations are in the public interest.
Thank you. Ms. Lewis, any questions for this witness?
No questions.
Mr. Amendola? Any questions for this witness? Mr. Savage?
Savage. Sure. And I apologize if I missed it in your filed testimony. I don't think I received all of it. But I'm representing Plat B and D, which are 30 townhomes that are individually metered for their interior use. But we currently have a irrigation 2 meters that has in the past been billed separately. And I want to clear on the record is that the division's position that with respect to Plat B and D's irrigation use, that Plat B and D, the HOA, will not be billed for that irrigation use, but each homeowner, the 30 homeowners, will be billed 1/30th of the usage on the irrigation meters each month.
That's my understanding, although the company would maybe be in a better position to answer that based on how their billing software
All right, but
is set up.
all right, I'll wait for that. So you would agree with whatever Ms. Wilson's position on that is?
Well, if it's the same as my position.
Okay, what's your
But,
what's your position with respect to the townhomes that have two separate meters right now for the HOA? Are they going to be considered a connected customer, or are those 2 meters not going to be considered connected customers?
No, the 2 meters wouldn't be considered a connected customer, and those meters would be put into a pool to accommodate the 30 townhomes, or Plat B and D.
All right, and then those individual homeowners would get 1/30th of that irrigation usage attached to their bill each month.
That's correct.
Okay, thank you.
you. Mr. Lang, any questions? Do you have questions for Mr. Long about his recommendation as to the Red Pine Clubhouse billing? Okay. Mr. Grenny? Mr. Martin? Thank you.
Pardon me, perhaps at this moment, it might be appropriate to take a break even now to have Mr. Lang prepare copies
Okay.
of the surrebuttal that he did not electronically file, so the division has not seen them. And I'd like to note that the division is not waiving any objection it may have to the untimeliness of this surrebuttal testimony
Thank
at
you.
this point.
Let's go ahead and take a break then. Mr. Grenny, if you will give me your, do you have copies? Mr. Lang, sorry, do you have copies? All right, if you will give that to me, I will run some copies.
And one question before we break. Mr. Lang, did you serve the surrebuttal testimony electronically on the parties to this docket? Did you serve the parties with your surrebuttal testimony electronically?
I was unable to do that.
Did you serve them by mail?
I was unable to do that. This was the very first meeting of this because I was traveling. So this was done this morning at 5:30.
Thank you.
Let's take about 10 minutes. we're back on the record. Ms. Schmidt, do you have any other witnesses today?
The division does not.
Thank you. Ms. Lewis?
Your Honor, Emily Lewis for Community Water Company. So we would just like to say that we anticipate this hearing being relatively short because, as the division has indicated, we have resolved the majority of the issues here today. We would like to make some comments just summarizing the company's final position on a couple matters, stating our support for the division's new recommended and amended rate, and then also making ourselves available for questions. Really, most of this case is focused around two issues: the scope of the rate, that we'd like to just make one or two introductory comments on, and then Mike Folkman is going to testify, and then also billing procedures, of which we're going to make one or two introductory comments on, and then we will call Ms. Stacy Wilson as our witness to briefly summarize on the record here in the general rate case our final billing methodology and answer specific questions. So, as Mr. Long indicated in his opening statements, that this is a company in transition. We are looking to transfer the company to a new owner. That is currently leaving us in a state of open negotiations, of which where we are looking for pragmatic solutions to fund a large deficit of improvements that have lapsed over the years. So we addressed this in our direct testimony and also several data request responses regarding priority improvements, of which we would have hoped and would have liked to have included in the current rate. However, we understand that this rate is limited to an operations and maintenance rate, and we defer to the division's decisions not to include those costs, as estimates at this point in time are the best information available to us. I would like to make just one general comment about the division's response and rebuttal response regarding the use of prior rate cases. We agree that the use of prior rate cases is appropriate to establish the threshold for specificity in infrastructure improvements. We disagree with using prior rate cases as a metric for determining whether or not the company has timely complied with creating expenditure reports, as each rate case is different, and a future rate case may involve a completely different configuration of improvements than are previously presented in past rate cases. And so we would like the commission to not use those cases as a metric for that purpose. As for billing, I feel like most of the issues have been resolved, and so today is really just going to be a summary for the record on those issues, and then answer any outstanding questions as such presented by Mr. Savage and Mr. Lang today. So at that point, we just would like to call Mr. Folkman to have a brief summary of the issues and the scope of the case and our support for the rate. Mr. Folkman was also sworn in at the interim rate hearing, and we'd like to recognize that here on the record. And so with that, we'll move to testimony. So, Mike, have you testified at a hearing before the Public Service Commission or administrative law judge before?
Yes, the interim rating hearing for this case in September this year.
Okay. And have you submitted any direct testimony or surrebuttal testimony in this rate case?
Yeah, I did. I submitted the direct testimony and the rebuttal.
And, Your Honor, I'd like to move to have Mike Folkman's direct testimony and surrebuttal testimony admitted onto the record.
Any objection from any party? All right, those are admitted.
All right. Okay. So we're going to discuss the previous requests of the company. Mr. Folkman, on behalf of the company, did you submit direct testimony in this general rate case?
Yeah, I did.
Can you briefly explain to the commission what the direct testimony discussed?
Just basically that we were going through the negotiations with Summit Water to possibly take over Community Water, and that as part of that negotiations, we had to prioritize some repairs that needed to be made, basically.
Okay. And did your direct testimony ask anything of the division?
Yeah, we asked that they would include those numbers.
Did you include a list of improvements that Summit had requested?
Yes, I did.
And can you generally explain what that list included?
It was just basically an Excel sheet that included the repairs, meters, valves, pipes, and some interconnects with Summit that would fix fire flow problems.
And were there any costs associated with these improvements?
Yeah, there were. Most of them were estimates at the time.
And why are these cost estimates?
Mainly because with ongoing negotiations with Summit, it's hard to put a number on the fix, I guess you'd say. There's different fixes depending on if that negotiation succeeds.
And in your SIR rebuttal testimony, did you state, what did you state about the ability of the company to submit more precise cost estimates?
It's just difficult at this time to do that without knowing the real solution to the problem.
Okay, great. And so, is the, in your SIR rebuttal testimony, did you agree that the company would defer to the division's
Yes, we did.
decision?
Yes.
Great. And are you familiar with the recommended changes to the rate that the division has proposed?
Yeah.
And do you have any comments on the changes?
No, they seem reasonable.
Okay. And does the company support the new rate?
Yeah.
And then in response to the questions most recently raised by Terry Lang and Mr. Scott Savage, regarding regarding meters for shared uses at HOA clubhouses, is the company able to add a meter to meter the indoor use for the Hidden Creek Clubhouse?
We could.
Okay. And that's something that we could prioritize?
Yeah.
Okay, great. So in closing, the company defers to the division's decision not to include the company's priority improvement requests, and the company supports the division's new rate.
Yeah.
Anything else you'd like to add for the commission?
No, not today.
Thank you for your time, Mr. Folkman.
Ms. Schmidt, any questions? Mr. Amendola, any questions for this witness? So I'll just note that that question really is not relevant to the commission's decision, but I'll go ahead and allow Mr. Folkman to answer it to satisfy your concern.
You can, yeah, or you can confer.
It's been on the docket for a long time, but there's been a push lately, the last maybe year, to really make it happen.
Thank you. Anything else, Mr. Amendola? I'm sorry, I don't think we can go into that here. Ms. Schmidt?
I was going to object, saying that his question is beyond the scope of this hearing.
Yeah, it's something this hearing is not to approve or allow the transfer. So that's something you'll need to discuss outside of this hearing. And I don't think that we can answer that. Okay. Mr. Savage, any questions for this witness? Mr. Lang?
As soon as we get the numbers, I mean, we could do it. There's, I mean, within a month, I mean.
What
there's
do you
no
mean
real-
get the numbers?
As soon as I get the approval from everybody to do it,
Okay.
it's just a matter of
You
a
have
day,
the-
week.
Do you have the equipment?
Yeah, we have the equipment. It'd be fairly simple.
Okay, thank you. Mr. Grenny? Mr. Martin? Thank you. Ms. Lewis?
Okay, thank you so much, Mr. Folkman. At this time, the company would like to call its second witness, Ms. Stacy Wilson, who's going to speak to the billing methodology. This was discussed at the interim rate. We have made some changes, and so we feel it's appropriate for her to briefly summarize her direct testimony orally here on the record, and then also answer any outstanding issues. So, Ms. Wilson, let's see. Have you ever testified at a hearing before the Public Service Commission or a Public Service Commission Administrative Law Judge before?
Yes, I testified at the interim rate case in September
Okay.
13th, 2016.
All right, and have you submitted any direct testimony or rebuttal testimony in the general rate case?
I have.
All right. Your Honor, I'd like to move to admit Ms. Wilson's direct and rebuttal testimony.
Any objection from any party? Thank you. Those are admitted.
Okay. All right, Ms. Wilson, moving on to the company's billing methodology. The company has previously discussed its billing methodology at the interim rate approval hearing, correct?
Yes,
Has the company changed its proposed billing methodology since that hearing?
yes, we have.
And why did the company change its proposed billing methodology?
The company changed it to, let's see. Because of the new interim rate, we changed it for that.
Mhm. And then did we change how we proposed we were going to bill our customers at all between now and the interim rate hearing?
Yes.
Okay. And what were the primary concerns for which we changed the billing rate?
The primary concerns of how to bill and share the water use of the condo units, the shared irrigation.
And have you discussed these concerns with the interveners and the division?
Yes, I've worked directly with the customers to address their concerns.
Okay. And were there any other concerns?
Yeah, there was confusion regarding if the physical meters and connected customers, how that was going to be taking place, but we figured out it was going to be customer, that it was going to be actual customers, not the meters.
Great. And in your direct testimony in the general rate case, did you discuss the company's proposed billing methodology?
Yes, we did.
And does that billing methodology address everybody's concerns?
Yes, it does.
Okay. And does the division does the direct testimony address the division's concerns regarding the company's billing?
Yes.
Okay. And for the record, can we, though this is in your direct written testimony, can we just briefly summarize for everyone here to answer any outstanding questions, how the company is going to bill the various configurations of its customers?
Yes, I'd be happy to.
Okay. So let's start with single-family homes and commercial connections. How will the company bill base rates for single-family homes and commercial connections?
The company will charge one base rate per connected single-family homes or commercial connection and bill the owner.
And how will the company bill water usage for single-family homes and commercial connections?
Each connected customer receives their full allocation of the 12,000 gallons charged to the appropriate tier rate.
And billed in 1,000
Increments, yes.
1,000 gallon increments?
Yep.
And how about for townhomes with individual meters per home but shared irrigation? How will the company bill base rates for townhomes?
For the townhomes, they will be charged a base rate to the townhome owners, and then they will be shared irrigation on top of that.
And then how does the company intend to bill for the shared irrigation?
So there'll be, between the townhomes, there's 60 townhomes. It'll be billed 1/60th of the irrigation, and then plus the $33 for their connection fee.
Okay. And plus their metered independent use?
Correct.
Okay. And the 60 homes are referring to the Red Pine townhomes, but that's also going to be true for the other townhomes?
That's correct.
Okay, great. How about the water use at the shared condominium units?
So the company will be charged a base rate with each condo unit in the complex billed to the HOA.
And how will the company bill for water usage at the condominium units?
The company will meter all the domestic and irrigation usage at the condo units to total water usage. And then the company will do a rate structure by the number of the units of the complex, sorry.
Mhm. So they'll multiply the number of condo units by the
Yep,
division's rate
sorry.
structure?
Yep, that's
Great.
correct, I'm sorry.
Mhm. And then compare that usage against the total usage against the rate structure?
That's correct, yes.
Great. And is the result that each unit receives the equivalent of their full allocation of 12,000 gallons charged at the appropriate tier rate and billed in 1,000 gallon increments?
Yes.
And are there more specific examples that fully explain these situations in your direct testimony?
Yes.
And just in response to the questions of both the intervener Scott Savage and Terry Lang, if the company is able to add a meter to the Hidden Creek clubhouse similar to the Red Pine clubhouse, would we bill both clubhouses similarly?
Yes, we would.
And in that case, the irrigation for the clubhouse would be considered communal,
It would.
but the inside water usage would be billed separately and the clubhouse would have a separate base rate.
That's correct.
Great. I just want to ask you just a couple of final questions about the company's ability to bill for underneath the rate. How does the company intend to ensure its customers are billed correctly?
The company purchased new software that will bill the customers appropriately.
And has the company had an opportunity to use this new software?
Yes. So we've already billed the customers for October usage under the new approved interim rate.
And was it successful?
We did have a few minor adjustments, but it is now.
Okay. If the commission approves a final rate that is different than the interim rate, will the company be able to adjust for it?
Yes. The billing software is already set up, so all I'd have to do is adjust some numbers and get that done.
And then if the final rate is different than the interim rate, does the company have the ability to true up the difference for existing charges under the interim rate?
Yes, we do. It would just compare to existing charges. They would, under the interim rate, so we just give them credits and fees if that, whatever, we'd adjust the account. So,
Okay. So in sum, the company has adequately addressed any remaining concerns about the company's billing methodology. Is the company able to adjust any changes in the rate or true up differences between the interim and final rate?
yes, we can.
Okay. Anything else you would like the commission to know?
No, thank you.
And that concludes our testimony.
Thank you. So if you install an additional meter in Hidden Creek's clubhouse in order to address Mr. Lang's concerns, can you also true up that account
I can. Yep, I sure can.
for what was billed in October under the interim rate?
Yep, I sure can.
Yeah, we'd have to very much look at, because currently it's, we'd have to do some, little bit of mathematic gymnastics, but we would be able to.
Yep, we can do it.
All right, Ms. Schmidt, any questions for this witness?
Yes, I have a question. Wouldn't the clubhouse, the Red Pine Clubhouse, be billed at starting the date of the final order, as it was not considered as separate inside connection at the time of the interim order?
Is this a question for me?
Actually, it's a question for Ms. Wilson.
Okay.
So you're stating like, at the interim rate, it wasn't clarified, so it should have been billed as like under the irrigation,
Yeah.
or?
And I object to that question. I believe that's actually a question more for the commission and Ms. Wilson, as the order that, the final order should maybe include the scope of for what connections and the rate is applicable to.
To that extent, that it asks for a legal conclusion, I will withdraw the question. But just so I can understand, the clubhouse was billed how under the interim rates?
Which
So the-
clubhouse are we talking about? Red Pine or
Red
Hidden
Pine.
Creek?
So Red Pine was billed the 3320, and then they get the allotment sum of the 12,000 gallons per thousand, and then it just goes into the tier structures after that.
And Hidden Creek was billed,
Hidden Creek doesn't have that separate meter, so it was billed just as the 130 because we don't have individual meters over there at like irrigation, and it's all combined. So, but we're happy to add a meter to the clubhouse to make that appropriate and make it work for both HOAs.
but because you didn't have that ability when interim rates were approved, do you have the ability to true it up?
What we could do is figure out what an estimate is, or we could just have the rate clarify that for that particular clubhouse it's applicable as of the final rate, which would probably be the easiest and most graceful way to do that.
And would Ms. Wilson adopt counsel's statement as her testimony?
Yeah. Yes.
Okay.
Sorry.
Thank you. Those are all my questions.
All right, well, I still need just a bit of help. So for the October usage under the interim rate, the Red Pine condo, which has its own meter, was billed the base charge, and it also got its own 12,000 gallons at the tier 1 rate.
That's correct.
Correct. But the Hidden Creek clubhouse, which does not have its own meter, the usage of the clubhouse was spread among all of the residents, so it did not get its own 12,000 gallons at tier 1 rate.
That's correct.
Okay. I understand. Thank you. Any other questions, Ms. Schmidt? Mr. Amendola? Mr. Savage? Mr. Lang? Well, let's start with the underlying question. To what degree is there a risk that the company cannot install a meter for the Hidden Creek condos use?
Um,
0, we can do it.
Okay.
Yeah.
We can install a meter. We'll
Okay.
make it happen.
All right. Does that address your question, Mr. Lang? Thank you. Any other questions? Mr. Lang, any other questions? Okay, Mr. Grenny? Mr. Martin? Thank you. Any other witnesses?
No, that's it.
All right. So we'll go to the interveners, but Mr. Lang, let me just start with you and make sure that I understand your concern. And your concern is that the condo clubhouse at Hidden Creek currently does not get its own 12,000 gallons of use each month. Okay. All right, so if it had its own meter and were billed the same way that the Red Pine Clubhouse is billed, would that address your concerns? Okay, so if the commission's order stated that the new rate schedule would not be permitted to go into effect until after the Hidden Creek Clubhouse had its own meter, would that address your concerns? All right. Then I'm just going to go through the interveners, and if there's any testimony you'd like to offer today, you may do that. I do not remember which interveners were placed under oath in the last proceeding, so I'll probably just put anybody who wants to speak under oath today. Mr. Amendola. Thank you. Mr. Savage. Any objections?
No objections.
Any intervener? All right, thank you. That's admitted. Thank you. Mr. Lang. Any objection?
I would just like it noted on the record that his rebuttal testimony was not timely filed because there was not an electronic copy received by the commission nor by the parties to this case. However, the division has no objection to its admission.
Thank you. Any objection from any other party? All right, thank you, Mr. Lang. That is admitted. Is there anything else that you'd like to put on the record here today? Thank you. Mr. Grenny? All right. Mr. Martin? Thank you.
I
Go
have
ahead.
one question. To the extent that the intervener's testimony has not been admitted
Admitted.
to the record, would it be appropriate to swear them in and ask them if they would like their testimony admitted so they would be available for cross-examination so the commission could rely upon their
Yeah.
submitted testimonies?
Thank you. Yes, Mr. Amendola, would you like any testimony or comments that you have filed to be admitted to the record? All right. So do you swear to tell the truth today? And would you like to move to have your pre-hearing filings admitted to the record? Any objection? All right. Thank you. Mr. Savage, we already did yours. Yep. Okay, good. Okay. And Mr. Lang, we've admitted your rebuttal. Would you like your other filings to be admitted to the record? All right. And do you swear to tell the truth today? All right. And your motion is to admit your pre-hearing filings to the record. Any objection? Thank you. Those are admitted. Mr. Grenny? All right. And do you swear to tell the truth today? And the motion is to admit the pre-hearing filings. Is there any objection? Thank you. Those are admitted. And Mr. Martin? Okay. Thank you. So those interveners are under oath and are available for cross-examination. Ms. Schmidt, do you have any questions for any of the interveners here today?
No questions.
Ms. Lewis, any questions?
No questions.
Interveners, do you have any questions for one another? Okay, thank you very much. I have a couple of timing issues. I think it's very possible that the commission will be able to get an order out before the end of the month. Is Community Water Company able to install the necessary meter and update its billing software to begin billing the new rates, whatever is ordered, as of December 1st.
Yes, companies able to do both of those things.
All right. And if the new rate structure goes into effect on December 1st, meaning that November usage is still billed under the interim rate, does that create any concerns or problems for any interveners? Okay.
I have a comment on that.
Go ahead.
If the commission would like to address the addition of the Hidden Creek Clubhouse as a new connection that
Mhm.
wasn't included in the interim rate because it will have a new base rate, I think
Mhm.
that it would be appropriate to just leave it as, one less connection, so 504 under the interim rate and then 505 for the final rate as a new customer might be a good way to solve that shared irrigation issue.
Okay. Does any other party want to comment on that suggestion? Right. Well, I believe what I have what I need on the rates and on the billing. The division has also proposed a revised tariff that addresses some of the policies of the company. Is there anything that Community Water wishes to discuss there?
No.
Anything that any intervener wants to discuss there? All right. And does Community Water Company have the ability to file a revised tariff within 60 days of the commission's order, assuming the commission's order issues on or before December 1st?
Yes.
Okay. And is Community Water Company also able to true up from the, excuse me, from the October and November charges within 60 days of the commission's order?
Yes, we'll be able to do so.
Okay. Then I think I have what I need. Is there anything else that any party wishes to put on the record today? Okay, go ahead. Mm-hmm. Correct. Mm-hmm. Okay, so I believe that billing for past usage is not part of this rate hearing. If there's been a mistake or an inaccuracy there, you seek first to work it out with the company. If you're not able to do that, you can involve the division to see if the division can assist with billing issues. And if that's unsuccessful, then you can file a formal complaint against the company, and it's under that complaint docket that the commission will go in and calculate a specific individual bill and correct for it. Okay? Thank you very much. All right. I believe we've addressed everything. Thank you all so much for your participation, for all of the work that you've done pre-hearing. I know that it has been a very involved process, and I commend you all. And with that, we will close the hearing. Thank you.
Thank
But we're
you.
reconvening at 12 for our public witness hearing.
Thank you.